And hello, everyone. Thanks for joining us today. Just our quick standard disclaimer, this presentation is for educational purposes only. It's not legal advice and it does not create an attorney-client relationship. The side note on that is, of course, unless you're already one of our clients. We'll have some information at the end of the presentation here on contacting us if you have specific questions, as mentioned by Dan. Also, so you can get on with your day, we'll move through this information rather quickly to keep everybody on schedule. So let's start out with some background on wage deductions and where the rules come from. At the federal level, we're looking at the Fair Labor Standards Act. That's again, a federal law passed almost 100 years ago that relates to regulation of employee wage payments, among many, many other things. It's a broad law, but one of the specific things it talks about is employee wage payments. And of course, related to wage payments, one area that the FLSA covers is deductions from those employee wage payments. And within wage deductions, the FLSA specifically talks about employee uniforms. So again, we're talking about rules that govern deductions from employee pay, and specifically one of the examples that the FLSA hones in on are employee uniforms. So when an employer expects the employee to bear the cost of their own uniform for whatever type of work it is, the employer can't reduce the employee's wage below minimum wage or cut into overtime compensation if the employer is going to make deductions for an employee's uniforms. The FLSA uses uniforms as their prime example because it's the most common thing that an employer would make employees pay for through wage deduction. But kind of an overall theme in this discussion is you want to keep in mind that if you're making a deduction from pay, an employee must still receive in their check an amount that's no less than the minimum wage for the hours that they worked. In addition, they have to receive any overtime compensation. So you can't make a deduction for uniforms specifically, and we'll get into some other details here in a moment. You can't make a deduction specifically for uniforms that would be so large that if you divided the pay or divide the hours worked by the pay, you would take the employee below minimum wage and any overtime compensation that they'd earned. So you could possibly prorate some of those deductions over time so the employee stays above the required wage levels, but you can't do something with a uniform that would take them below the wage level. Another issue that the Fair Labor Standards Act addresses regarding employee wage deductions is the deduction being made for the benefit of the employer, or is it being made for the benefit of the employee? So employees under the FLSA can't be paid less than minimum wage if the deduction is for the benefit of the employer. So think of things like damage to the employer's property, shortages at the cash or theft from the employer. A deduction would still be considered for the benefit of the employer, even if it was the result of a loss caused by the employee's negligence. So if the employee does something wrong, they tip something over, it breaks, you want to deduct that from their pay, you can't do so if it's going to take them below minimum wage. There's workarounds for this, obviously. You could have payment agreement in place, some other things that we'll talk about in a moment, but you can't avoid this rule by having them pay you in cash instead of deducting from wages if that cash payment equivalent would take them below minimum wage. So what this really means is even if you catch an employee stealing from you, you still have to give them at least minimum wage payments and overtime for the paycheck until it's paid back. It's a very strict rule that is meant to protect employees over employers, basically, because the federal law presumes that the employers have the bargaining and influence power over the employees. If you do, as an employer, make a deduction for your benefit, say to restore your funds or your property, you've still got to give a minimum wage paycheck every pay period, no matter how long it takes to get back to you. We'll talk about some of the specifics of paying things back, but you've got to keep in mind that rule regarding an employee's pay. Even if they break something and want to pay it back, it's got to stay above minimum wage, and they're entitled to any overtime compensation that they earn. So we just talked about deductions for the benefit of the employer. What about benefits or deductions for the benefit of the employee? Some general things that you'd think about would be union dues, a charitable contribution, or insurance premiums. In those cases, the employee, even though this is for their benefit, they have authorized in writing that those amounts can be taken out of their paycheck. That works into the theme that we've been talking about of keeping an eye on the minimum wage and overtime payments. But if an employee has signed an authorization, you can potentially make deductions that would take them below minimum wage. That is permissible, but you've got to proceed carefully in terms of making sure you're following all the rules, and we are going to cover some of those in a moment. But there's kind of two different schools of thought to sum up this area of the presentation: benefits for the deductions for the benefit of the employer, and then deductions for the benefit of the employee. Those are things that you always want to consider before you're going to start taking money out of an employee's paycheck. Okay, employer loans. This is a big area where we get quite a few questions. It can be tricky, so here's some kind of general information on that. A loan or a salary advance should only be done pursuant to a written agreement. In other words, you want to have a document between the employer and the employee stating the who, what, when, where, why, how much. All those details need to be in there. The agreement should state the amount that will be deducted from each paycheck for the repayment time and the time frame that those deductions will continue. And under that circumstance, a loan payback could take an employee's paycheck below their minimum wage and overtime. But again, this is something that would be for the benefit of the employee, as we just discussed, and they would also be signing off on a writing at the time, right before the deductions begin, in detail of how and why they are allowing these deductions. What you need to consider is that if you're going to make an employee deduction for a loan, you've got to have the express written consent of the employee on every single term of the amount being lent to the employee, and then everything about the payback. Again, when, how much, how long, all those factors have to be in place. Another area that we see occurring that can be considered sort of like an employer loan is an advancement of PTO. That say somebody runs out of days off, they want to take some vacation, the employer says, yeah, I'll give you an extra 5 days off with pay. The employee takes that time and then they leave, and they still haven't reaccrued those amounts into their PTO bank. If you're going to do something when an employee is departing regarding advanced PTO, you've got to look at your state laws to make sure that you're in compliance. That's a whole unique area of vacation pay and PTO, coupled with the unique area of wage deductions and employee loans. That's an area where it sort of gets tricky. And now we're going to discuss the state law component, which we just started to touch on here. All right, so we started off with the Federal Fair Labor Standards Act, national law covering most employers. Now we're going to drill down a bit into the state rules. In addition to all the rules you have to follow for wage deductions at the federal level, you're going to have in many, many states an additional level of rules to follow with your state laws regarding employee wage payments and then deduction from those wage payments. they could be different, and you're always going to need to follow the law that is the most favorable to the employee, not the employer. So, so what are some examples of some of the state laws you might see regarding wage deduction? So they might list the permitted reasons for the deductions, the requirement for written authorization, requirement for the timing, meaning maybe it has to be signed right before the deduction occurs, requirement for the amount of authorization, and the repayment process. So here are some recommendations on state law considerations if you're doing employee wage deductions. Don't have a blanket policy if you're a multi-state employer that applies to employees in all states. It likely will not work. You need to consider each state if you're going to make deductions from an employee's pay. Don't have a blanket authorization document or policy in your employee handbook. Don't have something that says, I authorize this employee to take money out of my paycheck if I break or lose something. A handbook, policy is too broad, it's too general for an employee wage deduction. It's great for many things, but an employee wage deduction, it's not good enough. It's not specific enough, and it won't cover you in most states. So you need to consider state law again, and you should not have a blanket statement in your employee handbook that says we'll deduct when we need to. You've got to get more specific than that. Some additional considerations before you're making a wage deduction for an employee. You want to, again, think about federal law first. Does it benefit the employer or the employee? And you also want to think about the state law. You want to check if you're allowed to make the type of deduction you want to make under state law. You want to make sure you've got written consent from the employee that complies with the state law requirements before you make a wage deduction. You need to look at the amount of the deduction each pay period, or however frequently you're going to have it paid, and consider that with state law requirements. You want to look at the state law requirements, if any, for a repayment plan. And you also want to consider your options under state law. What do you do if you make a loan, or you've got an agreement where the employee is going to pay you back for some damage or something they refuse to sign the agreement? That's another state law consideration you might need to look at. So what are some prohibited deductions? Many states prohibit the employers from making deductions from employee wages for these. Again, this is general, but you need to look at state law. So lost or stolen property, a lot of times employees are protected, even if it's their fault. Damage to property, breakage, cash shortages, customers leaving without paying an employee, accepting bad checks. A lot of those are not prohibited deductions under state law. The state legislatures, when they pass these laws to protect employees, they just see that as the cost of doing business for employers, and they do not allow the employers to pass those costs on to the employees. If you've got evidence of, like, say, for example, a specific cash theft of a specific amount by an employee, that's also not something you do through an employee wage deduction. That's something where you contact law enforcement, tell them that you have a suspicion that your property, your cash was stolen, let them investigate it, and going from there. It's not something that an employer should wade into. We touched on this, but really the timing of your authorization for a wage deduction is extremely important. Again, you do not want to have a general policy in your handbook that's not specific and try to rely on that to make wage deductions from employees. You want to have instead something that's more contemporaneous in time. If you have something that's signed far, far in advance of the actual deduction, a lot of states will not honor that. You have to, again, look at state law, because some states won't let you have blanket authorization. It has to be specific amount. And it's a very important thing that you have as many details as you can in any deduction agreement with an employee, so that you're not getting hung up on a state law claim. We can certainly assist you with an employee handbook, but one thing we would not do would be to put that blanket policy in. But we can also assist you if you need some sort of discussion on a deduction from an employee, or if you want to get a repayment agreement put together. But the timing is super important. What about when an employee is leaving? If you're going to be making a wage deduction from an employee's final check, you want to again have the written authorization in place. You could state potentially, again, depending on state law, that their entire final paycheck would be taken to satisfy a loan. You can't do that in California. That's our side note there. One of the things that a lot of employers do is that they set up a contract or agreement, a loan repayment agreement, using maybe a promissory note with the employee for how the remaining amount would be paid. If the employee still owes you money when they leave and you're not able to deduct enough from the final check to get the amount owed, the employee in that circumstance, if they signed off on an agreement, would be in breach of contract. But even just as a side note, if you have this signed agreement with an employee that they're going to pay you back after they leave, if they don't pay, then it's a breach of contract claim. And what's going to happen is you're going to have to take them to court to try to recover the amount, to try to get a judgment against them and collect against that judgment. Just be forewarned, that is a time-consuming process. It's labor-intensive, and it might not end up being worth your time to go through the process to get a judgment and then try to collect on it versus the amount owed. That's just an FYI on the front side, and could be even a broader policy consideration of providing loans or not providing loans at all. What do you do if an employee refuses to sign an authorization allowing you to perform a wage deduction? If it's related to a loan, you could set up a structure in a separate contract. Again, you have to make a determination on the front side whether you even want to get in the loan business with employees and the hassle involved in trying to collect from them. Some employers may try to terminate an employee if they don't pay. That could be a potential option, but it would still be out there with being owed the money. The other consideration that you want to think about is with any type of wage deduction or loan repayment, you've got to treat everybody equally, fairly, and consistently. If you give loans to employees, you've got to make sure that you're basing that on neutral criteria, not something protected like, you know, age, religion, disability, race, national origin. It's got to be a consistent policy. Same with like if you advance PTO. It's got to be something where you are locked in and not going randomly picking and choosing employees who you're going to make a loan to. Same with the wage deduction process and payback process. It's got to be something that's consistent. That's something that we can assist you with on the front side before you even go down that road. If you're one of our clients, we deal with this frequently, and we could provide information to help keep you on the straight and narrow with the process. Remember, as we always like to say, compliance is not optional. You can check out our webpage, myHRcounsel.com, for information on our services. If you are a client and you've got a specific question on this, you can go ahead and submit a ticket through our portal. If you're interested in becoming a client, check out our site, and there's a lot of information there on our different services. Thank you everyone for attending today. We greatly appreciate your time, and we will speak with you next week.